Welcome back to BLOCKTV. This is Links in the Chain. I'm Ron Friedman. In this segment, we highlight major players in the blockchain and crypto space and examine their roles and activities and get their take on the news pulse. Today, we're delighted to be joined by Stephen Paley, a partner in the Washington, D.C. office of Anderson Kill, a high-profile blogger on blockchain and crypto legal issues, who also has a background in software development and, dare we say it, a Twitter influencer. Stephen, thanks for joining us.
Hi, Ron. Nice to be here.
Excellent. Before we begin, can you tell us a bit about your firm's blockchain and virtual currency group? This is a relatively new development in Anderson Kill. What do you do? Who are your clients?
Yeah, so our clients are all over the place. I mean, I've got a U.S. practice, but I'm a trial lawyer and a litigator by experience. And we represent, I have a kind of feed in two different worlds. One, I sue insurance companies when they don't pay our clients, mostly corporations. And it's a very old practice. It requires some pretty traditional lawyer skills and an understanding of fairly arcane insurance law. At the same time, given my software background, I found myself helping people build what I call compliance-driven software solutions, and also, given my understanding of both law and of the technology, helping people when they have disputes. So could be garden variety disputes, what I call magic bean disputes, where one founder gets squeezed out and doesn't get a token allocation they were promised, or might be something involving allegations of fraud or misconduct, or asset recovery, where somebody makes off with either fiat or crypto that they weren't entitled to.
So I'm guessing blockchain and cryptocurrencies, I mean, they've been around for the last 10 years, but really making the mainstream in the last 2 or 3 years. How many people that share your expertise are there around the industry? Are you a bit of a pioneer there?
So, can I tell you a little story? I know we don't have a lot of time.
Yeah, no, we'd love to hear it.
But the reason I got interested in Bitcoin originally was I decided that I was going to build a dispute resolution software platform. And I'll cut it way short, but I wanted to remove intermediaries, but I ended up having all of my data sitting in a Postgres database on Amazon Web Services. And I started looking for ways to get out of the middle and ways to program money. And I discovered Bitcoin in about 2013, and I discovered Ethereum soon thereafter, before the sale. I don't want to be self-aggrandizing, call myself a pioneer necessarily, but I would venture to say I've probably been in the space before most of the lawyers who are in the space at this point in time.
Excellent. Now tell me, I'm just curious, have you ever had to stand out in a courtroom and kind of break down what blockchain is, what Bitcoin is, what a cryptocurrency is, in front of a jury or lawyers or a judge that, completely out of left field for them, and you have to really explain the fundamentals in order to make your argument in court?
I definitely had to explain it to other lawyers in the context of resolving disputes. So far, I've been able to get things taken care of without having to appear in court. So I haven't provided this explanation to a judge yet. I've definitely provided the explanation to opposing counsel who didn't necessarily understand what they were dealing with, or frankly, to plenty of my colleagues, both within the firm and outside of it. And there's certainly a good deal of skepticism among attorneys, but there are also plenty of attorneys who understand, on the one hand, the potential promise of the technology, and on the other hand, sort of the practical reality that it's something that people are using. And if your clients are using something, you need to understand how it works.
So you have a big leg up there. Like I said, you're pretty active on Twitter, and kind of went through your feed for the last few days. You recently tweeted that the least interesting thing about crypto is security laws. That said, there are many in the crypto community and obviously in the news world who put a lot of stock into regulation, especially when it comes to Bitcoin ETFs. And just yesterday, we heard a new ETF proposal, which was issued by Reality Shares ETF Trust, and they're aiming to combine investment in Bitcoin futures alongside sovereign debt instruments. How significant are these ETF proposals in the wider scheme of things?
Well, So I got interested in Bitcoin because I wanted to find a way to guarantee that somebody would be paid if they reached settlement in litigation. That's what interests me.
Hmm.
Sort of practical use of technology, the benefit of programmable peer-to-peer money that doesn't require an intermediary. I'm not a securities lawyer. I certainly have, I can handle securities litigation. But so for me, it's personally not interesting because I don't do securities transactions. It's not part of my practice. It never has been. I don't find it terribly interesting. I never saw crypto as a means for capital creation. And what I think is interesting about securities law is there's a test, the Howey test. We don't have a single test for insurance in the same way. So it's not. I think it is significant to the extent that approval of an ETF will signal sort of greater regularization, normalization of the technology, acceptance, if you will. But I feel like it's already been accepted. I accept it. You know, my law firm, we have clients who pay us in Bitcoin. So
No kidding.
yeah.
But so ETF as a way of widespread adoption, maybe familiarizing the whole market with
Sure.
the technology and the capabilities. But you're not so concerned if it's passed or not. And it will have. We're all assuming that it's going to have some kind of influence on the industry, maybe even on the price. What's your thoughts there?
I mean, it's not a bad thing. I want Bitcoin to succeed. I like many things about cryptocurrency. There's an interesting philosophical question, which is whether or not regulatory compliance is consistent with certain Bitcoin fundamental ideals or philosophy. Right. Can it exist in a compliant way? I don't know if you remember seeing the kerfuffle or fuss about Gemini's ads in New York.
Yes, the revolution has to have rules, yes.
Yeah, I mean, I don't think that's necessarily wrong, and I actually think it is kind of good marketing. But there are certainly, Bitcoin ideologues who would take issue with that. But I just reread the white paper this morning. I read it, I don't know, probably once a month.
As one does, yeah.
It's not an ideological. It's a description of a protocol. It's not ideological. You can argue that everything is ideological at a certain base level, sort of a la Foucault or Derrida or French philosophers. But beyond that sort of meta deconstructionist, post-structuralist context, it's not an overtly ideological document. It's no more ideological than the original white paper. I wrote something about this earlier. The original paper describing TCP/IP. It describes a protocol. So,
okay,
people,
but when you hear some of the reasons that the regulators are giving, I mean, Jay Clayton, the head of the SEC, in his last public notes about this issue, he was talking about problems that we're aware of manipulation, of lack of liquidity. These are things that are holding up both authorization, but for those of us who are following the industry and the business, these are existing problems.
Sure. I heard him speak a few months ago in New York at a CoinDesk event, right. And he was asked about this. And yeah, I mean, I think the message that I took was the market's not quite ready for it yet. There's too much underlying manipulation. Perhaps the order book isn't clear. I don't personally. It doesn't impact my analysis or appreciation of the technology and its sort of long-term utility. I personally don't really care.
All right, I've got another one.
It matters more to people who see it as an investment asset.
Absolutely. Well, this is an interesting another legal question for you there. When it comes to legal issues in crypto, an interesting legal claim about investors' rights when it comes to ICOs has come out of our neck of the woods. I'm talking about the claim that a company is under no obligation to use investors' funds as set out in its white paper. And then investors have no ownership rights. And this all came up as part of a lawsuit against a venture capitalist here in Israel, Moshe Hogeg, who, for notice and for our viewers, is also an investor in BLOCKTV. I think it's a super interesting response. And kind of curious to see how that's heard by legal ears in the U.S. and what that might mean for ICOs or fundraising of this sort going forward.
So obviously, I can't speak to Israeli law.
It's going to be tried in Gibraltar, anyways.
Even less. At least I've been to Israel. I've never even been to Gibraltar. So I wrote something about 2 years ago called the ICO white paper, and I have to say I was incredibly prescient. I saw the future. One of the things I wrote was, you call it a white paper, a lawyer calls it evidence. If just thinking about it from in the U.S. context, whether it's a securities claim or it's a common law fraud claim, if you state something in a white paper and people relied upon that in making their investment, you've got a very good shot that fact is going to be used against you. And in the securities context, people, there are legal professionals, lawyers, write prospectuses. It was really not a great idea to take the notion of a technical white paper and turn it into what was essentially a prospectus. And I think it's going to cause people a lot of trouble. And some of us pointed this out a while ago and kind of laughed at or ignored. Same thing with the Twitter feeds, Facebook, Reddit, community managers on Slack who were people with very little business or securities experience. I think all of that stuff, Telegram channels, all of that communication will be used as evidence in securities cases and in common law fraud cases, breach of contract cases, unfair trade practices cases. It's all evidence. And whether or not it's dispositive is a different question.
All right, yeah, that's what I was going to ask. And if you were a judge or you had to adjudicator hearing these arguments, or let's put it this way, how would you argue against it?
How would I argue against it? Well, it depends on the language that's used, conditionality, how hedged things are, whether or not there are significant disclaimers, whether or not it would be reasonable for someone to rely on a representation. Let's say, for example, hypothetically, that a white paper said there's a chance that we're going to use some of your funds to go to Pluto, the planet, and set up a colony. The question would be, did you really think that was going to happen? Was it really reasonable for you to rely upon that? Right. So I think it would be case-specific, context-specific, and language-specific, and also jurisdiction-specific. One of the difficult things about ICOs, which again, some of us pointed out years ago and were generally ignored, was you're selling this to the entire world. So whose law applies? There are 180 countries in the world, right? Each of which, many of which have individual states, provinces, cities, all of which have their own separate legal regimes. So there's a very complicated choice of law question as well.
Interesting, and I guess as time goes on, and we're going to see more and more of these cases. We're going to need more and more lawyers like yourself. I want to jump over just another major legal story that continues to make headlines. We're talking about Quadriga CX in Canada. You yourself revealed a few days ago that the possibility that not all up on the up and up when it comes to one of the founders there, right? How do you see this case? What lessons can be learned?
So, yeah, I don't know for sure if, I don't know for sure if Omar Petrin and Michael Petrin are the same person. I just
raised the, yeah.
I just want to be clear. I'm not saying that they're the same person. I don't know. I simply found a court filing that had some interesting names in it and posted that on Twitter. What's the significance of that? I think it shows there's a fundamental business problem in running an exchange is you need key management.
Right.
And it's also helpful to have, I think this is perhaps an example of why there might be a benefit to some regulatory oversight if you're going to have exchanges holding consumer assets. If it's really true that one guy had the private keys,
Yeah.
That's insane. I don't think there are any exchanges in the United States where that's the case. I don't know, but it strongly supports the notion that is something that should be audited and certainly avoided.
And
But
maybe, yeah, maybe the exchanges themselves should make it publicly known whether they do or not, or how they handle those kind of things.
Right. And the flip side is there's security concerns. You don't want to give too much up about your how you hold things.
Right. Tough to find a balance there. I want to, before we go, tell us a bit more about your software background. So you're a developer, you're a coder. Where does that come into things?
So I've always been interested in computers and technology. When I was very, very young, my mother's a university professor, and there was a lab in the School of Education at the University of Delaware that had something called Plato, which was a pre-Park Labs computer system that actually had, my recollection is it had, I think it was vector graphics, but it had a flight simulator on it, and it captured my imagination. This was probably many years before you were born.
Computer games, we all went down that route.
Sure, but so I was interested in programming as a kid. I learned to program on a TRS-80, BASIC, and I went a slightly different path. I went to grad school. I was going to be a professor. Ended up switching over to law because of, in part, interest in technology and intellectual property. And I got busy with my law practice. But about 6 years ago, I settled a case in an interesting way and decided it'd be cool to have software to do that for me, and I started my own software business. My developer left me with some half-built software, so I had to learn how to program to finish it, and I did. Unfortunately, I wasn't really great at running a software company, but I still had a law practice, and I ended up doing the same thing that I had done for myself or somebody else. And that's kind of what got me engaged in it. I don't sell myself as a professional developer. I did some web development for clients in the past, and it's kind of fun, but it's not what I'm. It doesn't make any sense for me to do that professionally. There are other people who are faster, better, and cheaper. But the ability to understand code, to be able to, understand what clients are doing and speak to clients who are building things using software, I've found both it's really interesting. It's very different than the law practice I had before, and I think there's, I think there's some value to it. I have fun.
Yeah, and maybe with the use of smart contracts, we might see some of the roles attorneys, lawyers have generally had to do taken over by technology, but you're going to be there
I'll be the last buggy whip maker.
No, you're going to be there to see the need, to identify it, and to find the developers who can create the product. Stephen Paley, thank you very, very much for being with us. To our viewers, thanks for watching. We'll be right back.